Hi, I'm Richard Sakota, an attorney at Sterling & Tucker since 1995. Thank you for joining us for this segment of Ask an Attorney. Probate is the court process that occurs when someone doesn't plan to avoid the court system when they die. If you have a trust, the things in the trust pass directly and they don't have to go to court. You may have beneficiary designations, but sometimes people either don't do any planning, or if they do the planning, they don't necessarily achieve all their goals because they didn't put everything in the trust, for example. Or sometimes things happen that you can't anticipate. For example, getting hit by a truck, right? You get hit by a truck, you could sue the truck company, but you're dead, so they would have to do a probate and your estate would have to sue the truck company. So in these situations, you end up in court, and the probate process is designed to make sure creditors are paid, taxes are done, and then whatever is left goes to the beneficiaries of the estate. If you have a will, you can determine who those beneficiaries are and who will handle the estate. If you don't have a will, the state has a set of rules that determines who will handle the estate and who gets things. If you have a trust, your will might say give it to your trust, and your trust will then take care of things. But most people try to avoid probate because it, as I said, is a court proceeding, and that means you have lawyers, and if you have lawyers, it gets expensive. Typically, probates are not cheap, and if they can be avoided, people like to avoid them. Other disadvantages with probates is if you have a dicey family situation, it gives a forum for family members to make complaints to the judge. Whereas if you have a trust, it's much more difficult for them to cause problems, I guess you'd say.